What?
We are live. Happy Friday morning, everyone. The House Discrimination Prevention Panel. And we are finishing up reviewing and then voting on policy document, which you can find on our website, but the updated version will be posted sometime after this meeting. So let's get started and have Damien walk us through the changes. What's the panel's pleasure? Do you want to start where we left off, or do you want to touch on run through everything?
Where we left off, so we voted out if we want to today. Yeah, we're good.
Okay. Kelly and Taylor, is that right with you? We got yeses in the room. Okay.
Oh.
That works for me.
Accidentally logged in with my mic. Okay. Good, I'm muted. Okay, thank you. Let me get the document open. Okay, good morning. For the record, Damien Leonard, Legislative Counsel. In front of us here, I'm going to just pull it up on the screen. We have the clean version of the document, the new policy. So not much to go through on this. There are a couple instances where I need to remove the underlining where we've changed individual to person. Representative Kalaki noticed that I had forgotten to remove some of the strike through, but otherwise this is what we reviewed the other day. Yes. With no additional changes. Are there questions on the document? Hearing and seeing none.
Did we get to the bottom where we left off?
And I will send Mike a clean version that he can post.
And for those listening in, I'll have Damien review why we have a policy document and then we have a procedure document that is our next agenda item this morning. We'll be meeting until 9:20 for those that can be here. So we're voting on the our upgrades of the policy document.
That's frustrating. It breaks across the page.
Yeah, I think if you get rid of the space between the contact information and our links there, it might.
There we go. Let's get rid of that. Just go ahead and do this.
Maybe the one question I have is under contact the Office of Legislative Human Resources. We had a conversation. I'm okay if we keep it as it is, but I thought we were going to have something about which employees can contact the human resources.
Right. So this is up on page 3. We've noted on page 3 here, if you see contact a supervisor, contact the Office of Legislative Resources. So an employee may contact the employee's supervisor or the Office of Legislative Human Resources. The reason for this, it doesn't prevent a member from speaking to Arlene or Eliza, but Arlene and Eliza don't have authority over members. They have authority over staff, and in relation to staff offices, but they don't have authority over members. So that's why we've said employee here. But for purposes at the end, we've just left the contact information.
Okay, good. Thank you.
Yep. Other questions?
And you made the, on the last paragraph on the last page, changed filing a charge to making a complaint.
So, yep, there we are.
There it is. All right, I'll entertain a motion to,
To accept.
put a motion, we've got to move. I was moving last night. Brian's wonderful dance party. We have a motion. Do we have a second? Chris, Representative Matos. Any further discussion? All right, we will call the question. Representative Paella.
Oh, I just was turning my camera on for voting and
Yeah, we're voting now, so I'm.
Yeah.
So I'm gonna run through like a roll.
I gotcha. Yes.
Yeah. Representative Small,
Yes.
Representative Matos,
Yes.
Representative Kalaki,
Yes.
Representative Cordis, yes. Motion passes favorably, and we have adopted the amendments to our policy document.
Okay,
So we can move right into the procedure document.
great.
And
So-
thanks, Mike, for when you get the document for uploading that.
I just sent it to him, so he should hopefully get it momentarily. So let me just find the other document.
It's posted to the committee's website.
Okay, so here's the rules of procedure. So as the chair mentioned, we're splitting these from the policy for two reasons, really. The first is that under the old policy where they were included in the policy, it made for something like a 14-page policy, which is a lot for someone to read if they're trying to figure out what's prohibited, what's okay, what their rights might be. And you don't really need the rules of procedure unless you're actually filing a formal complaint. So we're separating those out. The other thing about separating them out and drafting them this way is as the panel moves forward, what we can do is similar to what we do with the statutes. We can just do an amendment to Rule 6 or to Rule 8 rather than opening up the whole document and going in and starting to go through everything. So that'll allow us to kind of address things more discreetly without affecting the whole document going forward. And also you can leave the policy alone while you update your rules of procedure as you find things to change and improve. Questions on that sort of background? Okay, so the definitions here, a complainant is a person who's experienced or believes themselves to experience discrimination or retaliation in violation of the policy and has contacted the panel. So this is basically you're a complainant when you've actually begun the complaint process. Investigator is the attorney or other independent individual or entity with whom the panel has contracted to investigate allegations in a formal complaint. The panel is, of course, the panel. Panel staff include the Office of Legislative Human Resources, Legislative Operations, and Legislative Counsel. And I've noted here in brackets, and this is going to be the main discussion point, outside counsel who provide administrative, technical, and legal support to the panel. So the big discussion here is going to be, where is it appropriate to have legislative counsel and where should you be bringing in outside counsel? And the real reason for that discussion is because of legislative counsel's role working for all of you. When we're handling a complaint that involves members in the building, oftentimes we're in a position where we have, well, one, we have a attorney-client relationship with all of you. And two, we're often put in a position where we work with the individual who is either the complainant or the respondent, or in some instances, both. And then we also work with the panel. So it puts us in a position where we have a 2- or 3-way conflict of interest. And even if we split our office up so that we have different attorneys working on different aspects and trying to wall ourselves off from each other, all of us still have that personal conflict of interest. So there's a point probably where the formal complaint has made it past the initial stage of review, and you go to the point of hiring an investigator, where outside counsel should almost certainly be brought in at that point. For things like evaluating a complaint on its face. So not actually determining whether what the complaint alleges is true, but just saying, if true, what's alleged in this complaint would or would not be a violation of the policy. That's something that we could probably continue to handle without a major issue. It's just once you start getting into the point of having to guide and provide advice going into the late stages of a formal complaint process, that conflict is going to get really difficult to navigate for us. And it would call our ability to provide, objective legal advice in the question at that point. So, yeah.
Does the head of legislative council also deal with legislators?
Yes.
Drafting bills? Okay.
Yep. So our chief counsel also does that. And she is typically involved whenever there's a major institutional legal question.
Okay.
Right now she's actually working with your counterpart panel, the sexual harassment prevention panel, going through their rules of procedure that they're in the process of updating. So she's very closely involved with both with that panel and then with also, presumably if I was unable to assist this panel, she would be the first person to step in.
In our most recent process, we did have a situation where if the complainant was not a regulated individual, but we did go through the process, and Ledge Counsel Jennifer Carvey represented one legislator. You
Right.
walked us through the process, but if the regulated individual that has a complaint filed against them, there would need to be a third.
Right, and to be clear, we're, as an office, we're also backing away from doing more than providing people with advice on what the policy provides. Because again, it calls into question our neutrality if we're serving as defense counsel for someone who's accused of wrongdoing. So it raises issues, especially if one attorney is serving as defense counsel and the other is advising the panel that's adjudicating the complaint. Even if there's no communication between us, there's the perception that we're in the same office.
Yeah.
And it may not be an entirely neutral process. So it's, to avoid that perception that that the office is working on both sides of the the bench if we were in a courtroom. I'm not sure what the right term is here, but working on both sides of it. And then therefore creating a process that at least has the appearance of not being appropriate and objective. We want to avoid that. So that's something that we've discussed internally. And we're pulling back from doing anything besides giving people advice on sort of, this is how the procedure works, but we cannot assist you in drafting and so forth.
So I did bring this issue up at the Speaker's office a few weeks ago. Has your office also had conversations with Human Resources or with the Speaker's office?
So I know I've been working with our Director of Human Resources. I've helped her identify firms that may be able to provide outside counsel with the thought that we would get a single firm on retainer. And they would assist the Office of Human Resources and the panels when it's inappropriate for legislative counsel to provide the assistance, or when it's a really serious matter that requires someone who has expertise in workplace investigations or something like that, which our office, we have, many of us are former litigators, but none of us have experience in workplace investigations. So if you get to a point where the panels or the Office of Human Resources needs to investigate alleged wrongdoing, then it's really important to bring someone in who has appropriate expertise in that.
I'm happy to see this in the procedure, and I could do a straw poll on from the panel about this issue. I also want to make sure that we have a process in place and funding available to support this, and I can follow up on that unless you have information about that.
So I think that's something that Arlene has been pursuing. Is I think in her budget request, she included funding for a retainer just for her office. But my understanding is that the initial retainer is not particularly expensive in the grand scheme of the legislative budget. But it, is something we will need to plan for and may need to have fit into the overall budget. Certainly, if we got to the stage where we had a really significant case that required a lot of time by an attorney and or an investigator, then the costs, you could run through that retainer pretty quickly. But that's something that we would just have to deal with within the legislative budget. I will follow up with Arlene and see if she's had any other conversations. I know she has been extremely busy dealing with legislative staff compensation questions because the NCSL compensation study that came in, and they need to get those questions resolved in time to get the Pay Act out. So there is that going on here too,
Okay.
but I think there's money being set aside to address this issue. We certainly don't have to get a firm on retainer before adjournment. That's something that we can work on
As needed.
interim or
And then there's always the budget adjustment process if we need it.
yes.
All right. Representative Kalaki.
What if we just, Damien, just in that number 4, say provide administrative, technical, and advice to the panel, but not legal support?
Well,
make a distinction.
so the Office of Legislative Counsel does provide legal support, but just up to a point.
Okay.
I think what I would say is, those and as necessary outside counsel.
Okay. Good.
So that would be, I think that would be there, and then we'll indicate later on in the policy where outside counsel gets involved. And so that hopefully will make more clear. Other questions? Okay, I'm just being conscious that we have about,
Let's make can I get a straw poll on this question here before we move on? Nancy Kelly and Taylor, do you, everyone that there is in favor of including this policy procedure addition, say aye. Aye.
Aye.
Aye.
I got 5. All right.
Just so I get a sense of the rest of the document, are there, is the rest that is here what was in our original policy but without changes?
Well, it's all been reworked. It is very similar though.
Like formatting and,
Formatting is yeah, completely different. There are a few differences, so I'll try to move quickly through this because we did just work on this recently.
okay,
And then get to the more formal pieces or the more heavily changed pieces, excuse me. Right, so we have definitions for potential complainant, regulated individuals, which are House members, the clerk, and employees of the Speaker of the Clerk's office. This is an important actual change from the underlying policy, and we mentioned it, or from the previous policy. We mentioned it when we were going through the policy. The House rules currently only provide jurisdiction over House staff and House members. Previously, our policy had read that all legislative staff working in the House. So, for example, if I was in House General and I made, inappropriate derogatory comments, I would be subject to the panel. The way the House rules read, that doesn't seem to be the case. So that's something that we had just flagged as potentially an update for next biennium to the House rules, and then with updates to the policy then. So just wanted to flag that. Respondent and supervisor, I think we know those. The next rule, Rule 2, covers the informal contact process. So any person can informally discuss an incident or conduct with any member of the panel without initiating the formal complaint process. To the extent possible, the identity of the complainant or potential complainant will not be disclosed to anyone except panel members and staff without the consent of the complainant or potential complainant. Members of the panel are required to discuss the policy and options for resolution, including the informal resolution and the formal complaint process with someone who comes to them. If a witness discusses an incident or conduct with a panel member, based on that information, the member is required to approach the potential complainant to determine if they want to pursue either the informal or the formal process. And again, this is all consistent with the current policy. If a supervisor or an employee of the Office of Legislative Human Resources discusses an incident or conduct with the panel member, again, the member shall approach the potential complainant.
I have a quick question
Yep.
here. I know you're talking about panel member, and it says panel member in the beginning of section 2 and section 3, but then it says that the member, should we say panel member there as well?
We can. I was just trying to cut words and vary the language a little bit, but we could say panel member if you'd like.
There are other times we use the word member, right? That means, could be a legislative member.
So I do that in a number of places, so I'm just going to commit to myself to clarify that.
Okay.
All right. And then in every instance in which a panel member is informally contacted, the member needs to inform the potential complainant and any witness, supervisor, or employee of human resources that regardless of whether the potential complainant wishes to pursue a resolution, the panel member has to inform the other panel members of the incident or conduct. The panel may need to gather additional information regarding the incident or conduct, and the panel is obligated to take immediate and appropriate action to ensure that the conduct does not continue. So there are kind of three pieces here. And this is, again, was in our underlying policy, but we do have to share with other panel members, because sometimes what you'll find is Representative Matos may have heard from one person, Representative Cordes hears from another person, and Representative Kalaki hears from a third person, all about similar conduct from the same individual, and that tells you that this wasn't an isolated incident. And then again, with the immediate and appropriate action, this is basically to ensure that inappropriate conduct stops and doesn't keep going on. It doesn't necessarily involve disciplining an individual or anything like that. It can be an informal conversation with the individual saying, you know, we heard about the comment you made or that incident, and we want to let you know that that could be interpreted as a violation and it needs to stop, so we don't end up with a complaint or an informal process related to.
I'm sorry, we're voting on an amendment for something we presented before today.
Yep.
See you all later.
So I have bracketed at the bottom, working in consultation with legislative human resources and counsel or outside counsel. This was, again, part of that discussion about outside counsel. What I would recommend for language here is that in every instance, the panel shall consult with either the Office of Legislative Human Resources or Legislative Counsel or both for these informal contacts. Again, the reason for that is just to ensure that you're getting a second set of eyes to say, this is what you need to do under the policy, so that we have that insurance that we're handling each complaint similarly, and also so that when there's turnover from biennium to biennium, new panel members don't inadvertently break with our standard process, which could then lead to an allegation that we're giving someone differential treatment. Does that work for the panel for me to add that language in?
Yes.
Okay, great.
So I could see the process being the chair would reach out to the Office of Legislative Human Resources.
Yep.
And Leg Counsel.
Yeah, and the way this has happened in the past in other instances is, again, typically it's the chair or a member of the chair that reach out and just say, hey, this is what we've become aware of. What are the next steps? And so it just gives you a chance to discuss and figure out if there's anything that you're overlooking or strategize about how to address things or get more information if necessary. Rule 3 is the informal complaint resolution process. So this is when someone speaks to a member of the panel and then asks for an informal resolution. Again, this would be requires promptly informing the other panel members of the request for informal resolution. Panel has to gather information in this instance and shall consult with either legislative human resources or legislative counsel or both as appropriate. And 2 or more panel members would meet with the regulated individual to attempt the informal resolution. The reason we do this is generally one panel member will do the talking. The other panel member is there to take notes and observe and contribute if necessary, but it allows you to have one panel member focusing on engaging in the conversation with the individual who may have engaged in the misconduct, while the other panel member is recording what's said, what's agreed to, and so that we can keep an accurate record about the incident for the future. And also so that we have a record of what was agreed to that's accurate and not, something that you remember 15 minutes after the conversation and you may forget some of the details.
When we're taking records, I think it's okay that we do it electronically, correct? But we would need to be able to follow secure processes, especially if we're using our own
Yep.
devices.
Yeah, if you're going to take an electronic record, you want to be able to password protect the file and control who has access to it. You can do that through something like Microsoft SharePoint. So if you're technically savvy enough to do that, you can password protect and designate who has access to the document. If you take physical notes, you could then give those notes to myself. I have a locked file where I keep records of that are sensitive. And so that would be a way to keep it securely. So there are options for that depending on how you do it. The key is that you don't have a sheet of paper or an open Word document sitting on your laptop or iPad or at your place in the committee room that anyone can see. That's what we really want to avoid happening.
There should be statements on what either that this is confidential material.
Yeah, and if for physical things, I have a confidential stamp in my office to designate things.
But if, let's say, Chris and Mari were in a meeting and one of them was taking notes, they would share these with all of us, but we wouldn't respond in email because all of that could be of record.
Yeah, this is, so I would need to check on the exclusions on the Public Records Act, but yeah, we want to be careful about sharing the actual description of the conversation in email. If you're going to share it, it should just be a secure file link.
We
Which
might
is
not
not.
need to. I mean, as a panel, we could have
Yeah.
a verbal conversation.
Yep, we can also,
Without sharing
right,
the-
we can also go into executive session for a few minutes to discuss off the record what happened. So it could be a verbal summary for 5 minutes
Yeah.
in a quick meeting. And we don't need to live stream that because it deals with a confidential personnel matter. The other important thing too is at the informal process stage, we're not adjudicating guilt or wrongdoing here. We're saying this is what was told to us, and we want to ensure that to the extent that this happened, it doesn't continue. But we're not actually saying you engaged in misconduct. We're just saying this needs to stop at this point. So sometimes it may be that someone was just insensitive or not thinking and said or did something that was offensive to someone else, and we just want to head that off so that next time it doesn't happen. Because it's the issue really arises when it becomes a pattern or when the behavior becomes sort of acceptable. And the informal process is really an opportunity for people to, without going through formal adjudication of wrongdoing, get behavior to stop and change. So that's what this process allows us to do, which is also why it's important to keep, just like everything else, it's important to keep this information confidential because particularly where there's no adjudication of whether wrongdoing occurred, that could be really damaging to someone if there's different versions of events and so forth, and we haven't made a finding. So following the informal resolution, just like under the existing procedures, it requires the chair to let the speaker know that there was a resolution, but without any details. Rule 4 is our covers the preventative action requirement, which we were just discussing. And this covers instances where the complainant decides not to pursue informal or formal resolution of the incident. If the panel determines in consultation with legislative human resources and/or legislative counsel that the alleged conduct could constitute a violation of the policy, the panel is required to gather information as needed and to take immediate and appropriate action to prevent a continuation. And then the appropriate actions may include formally contacting the regulated individual, the implementation of an interim safety plan, or the initiation of a formal process by the panel on its own motion. So that would be the most severe instance there, where it was clear wrongdoing, but for whatever reason, the individual who experienced it doesn't want to pursue the complaint. But the panel in that case could say, this is so egregious that we're going to pursue disciplinary action against the individual. The other two options are they're sort of an informal process where it's just an informal discussion with the individual who engaged in misconduct. An interim safety plan is something with the potential complainant, where you're developing a plan with them to ensure that they avoid contact with that individual or opportunities for the misconduct to occur in the future. And sometimes you may need to do both.
I have a question about Rule 4, A and B. Are those related or consecutive? So if a potential complainant chooses not to pursue,
Yeah,
but then
so
the panel in B is still required to move forward.
so in B, it's if you determine in consultation with legislative human resources and/or legislative counsel that it could constitute a violation of the policy, then you would go to the step of at that point just gathering any other information you need. This is really dealing with so you've got the statement from the individual and maybe a witness, and you look at that information and you say, is this a violation of the policy, or is this sort of it's not discriminatory, but it was people having a day where tempers were flaring in committee maybe. And if you do say this looks like it was discriminatory conduct or conduct that violated the policy, at that point you say, the next question is, do we need to take action to prevent future instances of this conduct?
Regardless of whether the complainant wants.
Right, because at that point, as an institution, we're on notice.
Yeah.
And if it appears that the conduct is reasonably likely to continue or reoccur, at that point, we are obligated to take action. If we don't, we're potentially liable when it reoccurs because we were on notice and we did nothing.
Plus, we would want to have a central location where this information was kept to determine whether there was a pattern or not, like you were saying. Especially
Right,
if we
so-
have different panel, a different
Yeah.
staff.
So A is really about making sure that the panel knows that something is happening and is aware of what's happening at each step. So oftentimes, the way one of these conversations has gone for the facilitators is, I got contacted today, I'll let you know what we hear. And then we had a chance to talk. The individual okayed me to talk to the rest of you. Can we discuss how this fits in under the policy? And then we meet, and then we talk to the individual. But it allows all of us to be on the same page, so that if two of us get, consecutive complaints about the same individual, we can say, oh, this is a bigger issue. Obviously, facilitators don't have authority that panel members do. With the panels instance here, you could basically say, hey, we're seeing a pattern, because two of us have gotten, a month apart complaints about the exact same behavior from the same individual, but against different people. And now we have reason to be concerned that this could continue and we need to take preventative action.
Yeah, that makes
Something
sense.
like that. So
I think in C though, if you are saying the panel can implement a plan,
yeah,
that has to be with outside legal counsel. Advice. The panel, if it's a regulated individual.
right. So the safety plan, an interim safety plan is really, it's addressing steps that the individual who's experiencing who's the target of the misconduct, or originally approached the panel about it, can ensure it's the panel's way of ensuring that individual is safe from that conduct going forward, or at least reasonably safe.
This seems like a
So-
human resources.
It,
Speaker.
especially if it's an employee who's approached the panel, it could involve working with the speaker or human resources or that individual supervisor. There are times where that's an appropriate step. There are times where that's not an appropriate step because there are no actions you can take with that individual that don't that aren't also arguably retaliatory, such as reassignment to a different, for example, if it was a committee assistant, reassignment to a different committee could be retaliatory. If that individual didn't want that. So, but this is definitely something where you need to be in consultation because every situation is different and there are going to be unique sort of considerations in every single situation that we just would need to take into account. So that's why at that point, you bring in human resources, you bring in legislative counsel. If it looks like it's very serious conduct, then at that point, I think you would bring in outside counsel for the formal process. And I can word this appropriately so it, indicates that I think what I'll do is just say that at any time the formal process is initiated, the panel shall be outside counsel and or an outside investigator.
Okay.
All right. All right, we're almost halfway. We're getting there. And it's 9:15, Madam Chair. Do you want us to pause?
Kelly and Taylor, how are you doing time-wise? Can you go a little bit 9:20 and Mike, is that also possible for you?
I think 9:20 is about my outer limit because I have to drive to the building. Granted, it's not far, but
Okay, we'll stick with 9:20 and
Okay. Sounds good.
So under filing a formal complaint, we've been over this before. Complaints need to be in writing. It does not need to be in a specific format, and it may be written by or on behalf of the complainant. The complainant can either submit an electronic copy to a member by electronic mail or provide a signed physical copy directly to a member of the panel. The panel shall ensure that copies are provided to all members and panel staff as appropriate, or excuse me, the chair. And if a panel member other than the chair receives a complaint, that member immediately notifies the chair. The complaint is supposed to include a description of the conduct at issue and identify the regulated individual who allegedly engaged in the conduct. And it can be submitted about any current regulated individual regarding conduct that allegedly occurred at any time during which the individual was a regulated individual. So this is one thing I just want to flag here, and this is there are some interesting nuances here because of the definition of regulated individual. In the unlikely event that a former senator became a state representative, the they wouldn't have been a regulated individual if they engaged in misconduct while a senator. Same thing if a former staff person becomes a state rep, if they are not a House staff person, they wouldn't have been a regulated individual. So for example, if Mike or I ran for the House, we wouldn't have been a regulated individual if it occurred while we were in our current positions. So that's just something to keep in mind with the way this is structured. So there are some limitations on that, but it is, if you've been a member of the House for 26 years, then the look back period is 26 years. So, yeah. Upon receiving the complaint, prompt notice to the speaker without any identifying information. Then this is a point to pause for discussion. So maybe this will be the place to leave off. Our current rules of procedure require that after receiving a formal complaint, the panel immediately provide a copy to the respondent and then request that the respondent file a response within 7 business days or additional time if the panel determines there's good cause, and then they provide that complaint to the copy of the response to the complainant. And then after all that occurs, there's an initial review of the complaint and response. One thing that we discussed in the past year was, what about when you receive a complaint and on the face of it, the complaint is about behavior that's just not covered under the policy? At that point, should we even require the respondent to go through the process of answering it before the complaint's dismissed? So the thing I'll leave you with is an alternative process would be to have initial review when the complaint comes in. And if assuming that the allegations in the complaint are true, there's no violation of the policy stated in the complaint, you could allow for dismissal of the complaint at that point, and just a note to the respondent that a complaint was submitted, but that it didn't state a violation of the policy, so it was dismissed, and then also notice to the complainant as to why it was dismissed. So that would allow you to basically head off that 7 business day turnover and lag there for actual response. When you get a complaint, for example, the individual files a complaint, but it's about something that happened before a regulated individual was actually a regulated individual. So we have no jurisdiction and there's nothing we can do at that point. You could just say dismissed.
Does make, I mean, we definitely should talk about it more, but it does make sense to be able to have some sort of initial review before going to rule 6.
Okay. I'll add that.
Any other discussion, Kelly and Taylor, on that?
Not at the moment. No.
Does that, and Chris, does that make sense to you?
It does, yeah.
Okay, and that's I think as far as we'll get. I'll make updates before our next meeting, and we can hopefully go through those quickly and then pick up and finish the next time we meet.
Yeah, so that's the goal. Finish the document, vote, and get it uploaded to the website by the time we adjourn.
Joint to meet next Friday,
Yes,
same
please.
time, same place.
Could we try meeting at 8:15 next Friday? Is that pushing it for you, Damien?
It is pushing it for me a little bit. I can try my best, but it's I'll try to come straight upstairs when I get into the building.
You sure? We could keep it 8:30.
We could do 8:20.
Okay.
That's easier for me.
Okay.
So it's just really tight on Fridays. So,
Yeah. I understand.
Okay. I'm gonna jump off just because I gotta jump in the car.
All right, we'll see you soon.
Okay. Yep. Thanks.
Thank you. All right, so next Friday, 8:20, Mike will find us a room and
I
go
think this
ahead.
room is reserved for us for the rest of the session. On Friday.
Great.